It's horrible what they did to her.
No eyewitnesses, no forensic evidence, no physical evidence whatsoever connecting James Dailey to the crime.
It has been 34 years since a Tampa Bay teenager was murdered. Shelly Boggio's murder is known as one of the most violent crimes in Pinellas County's history. 2 men were convicted of her murder, but only one of them is sitting on death row, James Dailey. 10 News reporter Liz Crawford talked to Dailey's attorney, who says his client is innocent.
There's overwhelming evidence of his innocence.
Josh Dubin works for the Innocence Project. He's representing James Dailey, who's sitting on Florida's death row. He met Dailey Tuesday.
It was somber and it was emotional, and yet there's this interesting resilience and flicker of hope that the governor will listen and that the clemency board will listen.
Dailey and his friend Jack Percy were found guilty for the 1985 murder of 14-year-old Shelly Boggio. She was beaten, choked, stabbed more than 30 times, and held underwater until she drowned. 10 News spoke to the man who found her body in 1985.
I really didn't know for sure until the police, the officers, patrolmen went over there. And then when the body was pulled up on the bank, you could see blood coming from the neck.
Was the body clothed?
No.
Pearcy was sentenced to life in prison. Dailey, who is now 73 years old, was sentenced to death. But now, 3 decades later, Pearcy admits he acted alone in killing Boggio.
He has said in no uncertain terms, in a sworn affidavit, James Dailey had nothing to do with this.
But he didn't say that in 1985, 86, 87.
Correct. This didn't happen until a few years ago that he finally came clean.
Boggio's family doesn't buy it. Her cousin, Andrea Boggio, plans on traveling from Michigan to Florida if and when Dailey is executed.
It needs to end. We need justice. Her life needed to matter. She was only 14.
There was no eyewitnesses.
No eyewitnesses, no forensic evidence, no physical evidence whatsoever connecting James Dailey to the crime.
It was brutal. It was a brutal attack. She didn't have a chance to do anything with her life.
Now to an update in a First Coast News investigation into a murder case dating back to 1985. For 32 years, James Dailey has been on Florida's death row for a crime he says he did not commit. The 73-year-old Vietnam veteran was granted a delay in his execution when his attorneys presented new evidence back in October. But that delay just expired. On your side, Shelby Danielson has new details tonight as his fate could be decided any day now.
James Dailey is convicted for the murder of 14-year-old Shelly Boggio. However, another man has come forward saying he alone is the killer. The question now, will that man's confession be enough to turn this case around?
Nobody forgot. Nobody's going to forget.
Andrea Boggio is the cousin of murder victim Shelly Boggio. She made her feelings known to us back in October when Governor DeSantis had just issued a stay in execution for James Dailey to allow his newly appointed attorneys more time with the case.
It's not fair that this guy keeps getting chances.
She believed Dailey was guilty then, and she still believes that now, despite new evidence entered into court by Dailey's attorneys. According to court records, Dailey's attorney visited inmate Jack Percy at the Sumter Correctional Institution. Pearcy was also found guilty of Shelly Boggio's murder, but he was given life in prison instead of death. He has admitted to being the sole killer before. But on December 18th, he voluntarily signed another declaration claiming that he alone killed the young girl and that Dailey was not even involved. He elaborates in a statement that says in part, quote, "Dailey was back at the house when I drove Shelly Boggio to the place where I ultimately killed her." Organizations like the Innocence Project, Floridians for Alternatives to the Death Penalty, and Catholic dioceses across the state have come out in support of Dailey.
I believe he's innocent based on everything that I've been able to experience and to read. How are we going to be at peace if we have killed an innocent man? Meanwhile, Andrea Boggio says the new developments have only caused her family more pain.
She tells us, quote, "There is already so much loss. We are absolutely disgusted that this is still going on, and we are just ashamed of the state of Florida." The governor will either assign this case to a clemency board so they can review the 100 pages of new evidence, or he will assign a date for Dailey's execution.
It has been more than 3 decades since a Battle Creek teenager was brutally murdered in Florida. Now her killer may finally be executed.
A relative of the victim who still lives in Battle Creek is hoping the family's long-awaited justice is finally coming.
13 on your side's Brent Ashcroft has been following this controversial case. Recently spoke with that family member here in Michigan. He joins us now with more. Brent.
Shelly Boggio grew up in Battle Creek. She was only 14 when she died in 1985. 2 men were tried, convicted, sentenced, and imprisoned for killing her. One of them received the death penalty for it. But new evidence in the case is sparking attorneys to fight for exoneration, something a Boggio family member here in Michigan says would be an unconscionable development to a tragedy that's consumed her whole life.
34 years. That's all of my adult life.
The execution chamber, Florida State Prison.
We all thought that it would happen a lot sooner.
Andrea Boggio plans to fight through her fear.
I have never stepped foot in the state of Florida because I'm afraid I'm going to die.
Occupy one of these seats.
It's hurt too many people.
And watch.
It's not like he just hurt her, he murdered her.
As James Dailey is put to death for killing her cousin Shelly.
Her life needed to matter.
Shelly Boggio and her family moved from Battle Creek to Kenneth City, Florida in 1984. A year later, she found herself in the wrong place with the wrong people.
It's horrible what they did to her.
Her mutilated body was found along Indian Rocks Beach.
They stabbed her 31 times and drowned her.
Witnesses said Shelly was with 2 men that night, James Dailey and Jack Percy.
She was seen in a bar with them.
A knife belonging to Pearcy was found near Boggio's body, but when questioned by authorities, Pearcy implicated Dailey. Both men were tried and convicted of first-degree murder. Pearcy was sentenced to life. Dailey got death. No physical evidence or eyewitness testimony linked Dailey to the crime, but statements from 3 jailhouse informants did. He's been on Florida's death row since 1987. 2 years ago, new evidence surfaced that Dailey's attorneys say casts doubt on his guilt. A signed affidavit from Pearcy saying he alone was responsible for Shelly's murder. But when he testified in court about it, Pearcy invoked the 5th Amendment.
How are we going to be at peace if we have killed an innocent man?
This development triggered some Florida groups to call for Dailey's exoneration.
I believe he's innocent based on everything that I've been able to experience and to read. But because I am a death row minister, I can't talk about that or analyze it, but I believe it.
There is something about this story that calls a more careful review.
Florida's governor signed Dailey's death warrant in September. Dailey immediately filed an appeal, which was later rejected by the Florida Supreme Court. His execution was scheduled for November 7th, but Dailey was awarded a temporary stay until December 30th because federal law allows 90 days for his new legal team to review the case.
It's not fair that this guy keeps getting chances.
The burden of waiting has fallen on Andrea.
It just keeps coming back.
And 3 of Shelly's half-sisters, because everybody from Shelly's immediate family is gone.
It's up to us members that are left to do this for them.
Is the state of Florida about to put an innocent man to death?
This is a gratuitous killing. It's not going to bring anybody back to life.
Will the Boggio family get what they believe is justice for Shelly?
He committed it.
If Dailey is finally strapped to this,
I don't have any pity for him at all, and I won't.
Andrea plans to travel from Battle Creek and be here to witness their 34-year nightmare.
An eye for an eye.
End.
Shelly isn't forgotten.
James Dailey's attorneys have until December 30th to make their appeals in court. They're trying to request a new trial so they can enter the new evidence, which includes witness testimony and Jack Percy's affidavit. Meantime, Andrea will continue to wait and hope
that justice will ultimately come for Shelly and the few remaining members of the Boggio family.
Governor Ron DeSantis has signed a death warrant tonight for James Dailey. He was convicted of killing Shelly Boggio in 1985 near St. Petersburg after picking up the 14-year-old and her sister. That execution is set for November 7th at the Florida State Prison.
I have deep respect for the court for showing a man that has had no respect for this process as much respect as you did. I thought that it was really remarkable because he is, it's no doubt clear from his phone calls that he thinks that this is all a game. And he thinks that he can keep on, when he tells the truth and he comes in and he changes his mind, he thinks that he's in control here. So what we would ask is that he be put on the witness stand. I will start putting questions to him. If he wants to answer, he can answer. If he wants to take the fifth, some of the questions, there would be no right, all things being equal, for him to take the fifth. The Florida Supreme Court has already ruled that he has no right to take the fifth to any question, right?
I agree.
So what I would ask Your Honor, and again, I say this with what's the best way to articulate this? With the deepest respect I can muster and lay out for you in the wealth of this courtroom. We would ask Your Honor that if he continues to refuse, to indeed hold him in contempt, because this is a serious process where, as the court is aware, my client's life literally hangs in the balance, and he's showing no respect to the process. He thinks he can just come in here and do what he wants.
Okay, but what's the point in holding him in contempt if he knows it's not going to do anything to him? I mean, how does that move the ball? Because that's what I'm trying to do, is get him to testify. So how does that move the ball?
It maintains the integrity of this process. I understand that it may not ultimately move Jack Percy. That's all. I think that it's a slap in the face of this process, the way he behaves.
Well, as to whether I'm going to treat him with respect, my policy is to treat everybody with respect, whether they've been accused of crimes, convicted of crimes. It's not always easy to do, and sometimes we forget that it's necessary, but it's necessary. And people don't like the system sometimes because they feel like the system's being disrespectful to them. Many's the occasion over the past 25 years that I've watched two individuals get the exact same disposition for the exact same crime, be it a misdemeanor, a felony, or more, and one side walks away thinking they got it treated horribly. The other side walks away thinking, everybody was pretty nice to me. It's a matter of perspective. Being nice to people doesn't cost anything, so there's no reason not to do it, if we can. However, if you thought that there was a way I could bully him into testifying, I would try it if I had it, but I don't think there is. Let me hear what the state has in the way of ideas for me to get him to testify, and after that, I'll tell you what my idea is. State, you got anything left for me?
No.
Okay. So here's my idea. His mom's here, and she seems like a really nice lady, and I've listened to her talk to him on the phone, and she cares very deeply for him. I can't control the situation, and they say you should never let the situation get out of your control, but my thought was, why don't I let her go in the back and ask her son to testify and put this to rest, if she's willing to do it, and there would be no record of it because I can't make a record of it. I'm not sending a court reporter back to intrude upon them, but it would be the rare occasion that they know that the conversation isn't being recorded or supervised or observed, although of course I'd have to have a sheriff's deputy stand back there to make sure she didn't pass anything to him, but I'd give him the opportunity to talk to see if she could persuade him to do this defense. Do you have any objection to me taking that course of action? I'll let you confer if you want to confer. All right. The same questions come to you, State. So. I did? Yeah. Why is somebody saying I did? Oh, all right. Yeah, no, it's broadcast.
Yeah, you're on.
Yeah, all right, so
what
are your thoughts?
What our thoughts are is, we had, again, someone much smarter than me gave me an idea.
Okay, tell me.
Clear from the calls, he does not want to be here in the county jail.
Great.
And Your Honor could tell him he's being held in contempt, and being held in the county jail for the next 30 days, and we adjourn the hearing and come back here in 30 days, and give him 30 days to think about it, so that there's a real consequence to him not testifying.
Okay. State, what's your insight on that one?
We want this over today.
All right,
We've
I agree.
been through this over and over and over again. We want this done today.
We want the truth, Your Honor. And if it takes another 30 days, he's waited 34 years. What's 30 days?
We have had 34 years. We know the truth. We've heard the truth. We've had trial after post-conviction, after post-conviction, after post-conviction. We've had multiple sworn statements from Mr. Pearcy. Enough's enough. The state's position is we have today, and it's done.
All right, so what do you think about my plan to send Mom back there to talk to him if she's willing to do that? Defense, you willing to go along with that, or is that a no-go?
We're willing to go along with it, and then we would ask for our recommendation to be Plan B.
I'm still contemplating your recommendation. I haven't taken that off the table. I'm just trying to find an avenue that gets us actually him talking to us rather than me trying to swear him in and then him staring at you guys and starting to argue and frustrating our poor court reporter, because that's not gonna get the answers to the questions. State, you got a heckler's veto. Are you in favor of it or against it? Because it's unique outside the box thinking, but I'm not going to do it unless both sides are willing to turn their keys on this one.
Yeah, that's fine with us.
You're okay with it? Okay, let's see if she's willing to do it. Sarge, I'm sorry to put you on the spot. Can you do this? Okay. All right. It's Miss Simon, right? Miss Simon, could you come up here again? Sir? Yes, sir? You can come up with her also, sir. Okay, but is there anything we're going to have to do there? So you guys know the rules in there. Okay. Okay. Sure, what's your name for the record?
I'm Robert Simon. I'm the fortunate guy that got to marry his mom.
Okay, all right.
I've been married 25 years. I've gotten very close to Jack.
Okay.
Over those 25 years.
So your pitch is you want to go back there with her and try and help
that
persuade
would
her?
be permissible. I'd appreciate that.
I'm open to all ideas and all avenues. Defense, any objection to letting Mr. Simon go back as well? Defense, any objection to letting Mr. Simon go back as well? Okay, so the question is, are you two willing to try and help us all out here by getting an ultimate resolution to this situation so that I can hear from Mr. Pearcy? Your husband got a chance to hear the pitch that I made to him, and I wanted to let you know, ma'am, that if he testifies, I'm going to make sure that both sides treat him with respect. I'm going to make sure that he gets a fair chance to tell his side of the story. It's been 35 years. He's never gotten to tell his side from the witness stand. I know that I've read depositions from him before. I know Judge Casada tried to force him to do it. I'm trying to appeal to his better nature to do it. So if you think you can help me with that, I'd be willing to give you 5 minutes to go back and talk to him. Would you?
I would like to do that.
We would like to be permissible. We'd like to.
So that this could be taken care of for both sides.
We'll get this done today.
Okay. Well, then the record will reflect that both sides have agreed to allow me to do this. It's unconventional, but we're going to take a shot. Now, the deputies are going to tell you what the rules are back there as far as how you're allowed to be.
I'm hopeful that it's being recorded, right?
It's not. That's the thing. This will be the rare occasion that you get to talk to them back there and nothing's being recorded, okay?
Well,
So,
whatever. Either way is fine.
A rare opportunity for a private conversation with your son, okay? So if you could go with the deputies, they'll make this possible, and unless there's something else we can do, we'll be in recess for 5 minutes because they'll walk this way. Neither do I.
Well, I've got a muscle disease.
My husband's like
That's fine.
Okay.
Just don't walk this.
Okay, so both sides are okay. And I know all of you well enough to know that forcefully, if I was doing something you didn't want me to do, that somebody would have objected strenuously. So I am confident of that, at least. All right, so let's be in recess for 5 minutes and see if the sirens can work their magic and make this happen for us. Oh, you want? Well, you know what? Is it okay if we? You don't have to stand. It's okay. Y'all may be seated. Is it okay if Mr. Dailey stays out here just so that we don't have him back there with what's going on back there? All right. So, Mr. Dailey, you can have a seat and relax. Okay. That's my water tank back in my office. I'm going to get it.
It's getting really late. I think he's here. Should be about 1,000 a year.
That looks good.
Oh, really? Maybe she's big with this thing coming. No, you have to get 3-step runs. Sure. Because then I'm deleted. You're like, I'm just deleted. Exactly. Yeah. It's like another this upstairs and she's like, we found it. Yeah, sure he's still there. That's what they had down like this for more than yeah.
I said you guys even needed no idea.
Just tell them yes. Break. I need to use the bathroom.
Which way they can someday. That's right.
Come to the table.
Fine arts. You can do that.
Well, lunch and water. Because they got to that point there, that's two. Why would he start?
That means
I'm gonna have that cardigan in my hand, but I didn't need the officials. I love them. So, lost the sergeant. Where? It's oh, sorry. No, that's our 17. I think you're special.
Well, it's just bring it 6. No, we better jump down. So, no. The bars look snappy. Show them trying to stand still. I'm gonna get some. Huh? The bars look snappy on his. When are you gonna get some?
You're playing? Yeah, you got to dress up a little.
Dude, there's days when I want people to think that I've been here the 28 years that I have.
The best is when you get
like, I want people to think I just started.
Yeah, the best is you got the head too. It's like I've been here 2 years. You know, all we have is pain and seniority, so you got to dress up.
I don't need to advertise.
Yeah, some days you're like, oh, I've been here that long.
Well,
You start getting like 6 starts.
I go, I just started yesterday. Because a lot of people think I was born yesterday.
Right. Yeah. All right, bring it.
Okay.
Right up to the
Right up this way, man?
Can't believe the manpower you got.
You're just gonna go right up this way. Just back to their seat, Charlie?
Well, actually, they can come to the
Back
podium.
to the podium? Okay, right over to the podium again.
You got to see the back there, right? It's not very exciting, is it? All right, we're back on the record. State is present, defense is present, defendant is present. I've allowed mom and stepdad to talk to Mr. Pearcy to attempt to convince him to testify in this case. What do you think after you talk to him? Am I going to be able to get him to testify?
Well, I'll let my husband speak.
Okay.
We did, we talked to him.
Okay.
And we expressed your desire to have him testify. And I told him, I says, and this is the words I told him, I says, we feel you ought to testify, but we're not, it's totally your decision.
Okay.
And we mentioned several times that you ought to be questioned. Basically, his comments was that he was under oath and questioned for about 3 hours in a couple of weeks ago.
All right. Well,
And,
I'll try and explain to him that doesn't work, that
Well,
he
I'm
needs to
just-
testify in here.
I'm just letting you know the conversation. We tried and suggested that he do that.
Okay.
So
I'll bring him back in and I'll talk to him again and see if we move the ball, okay?
we didn't tell him not to.
Well, I would hope not. That wasn't what I was sending you back there for.
Just like, what I'm doing is letting you know that we
Okay.
didn't go back there and go against
What you,
what you asked.
You didn't try and strong arm him either, then, right?
We never once mentioned, don't do it.
Okay, all right.
no, because
me,
we respect the court.
Okay, well, I appreciate that, okay? Thank you for being here today.
And thank you for being kind to him.
Oh, you're welcome. Okay, so how about we combine Plan A and Plan B? I bring him in, I try and swear him in, and I try and get him talking. What have you got?
Judge, my concern is that if you execute Plan B.
Yeah.
And you then hold him in direct criminal contempt,
Yeah.
which you would have to do to put him in Pinellas County Jail.
Yeah.
He's entitled to an attorney.
He is.
And a hearing.
Yes.
Okay, we just wanted to make sure you were aware. That is another process.
There's a
that we're
whole
gonna
other
go through.
process that we're gonna go through.
I've been down that exciting adventure before. I didn't say I was going to hold him in contempt. I said I was going to bring him in and start Plan B. And Plan B, my understanding was y'all were going to ask him questions as though we're just doing this. And sometimes that works. I know you tried that with Judge Casada and you didn't get very far. We're out of football season and into baseball season, I guess, so I'll do a 3-strike situation. If he invokes 3 times in a row, then we're done. I'm not going to let you just sit there and ask him questions while he invokes. I'm not doing that. But if you can attempt to be persuasive and get him talking, I'll be more than willing to let you try. I've now had his mom and stepdad talk to him, and I've had the long talk with him, and nobody's got any other ideas of what to say. But just holding him in criminal contempt's not going to do it. He's already told you in the deposition a couple times he's not going to do it. So
I have one.
You got another idea? What do you got?
Well, there's 2 people in this building that know what actually happened. Okay? One of them is sitting right there, and one of them is back there.
Okay.
Would you allow James Dailey to tell him to come out here and tell the truth?
Okay, that's a unique approach. Hadn't really contemplated that as an option. So you want me to let your client talk to him here in front of everybody?
No. Oh, however Your Honor wants.
Oh, no, I'm not sending the defendant and the co-defendant in the back to talk. That's not going to happen.
Give it right there.
Yeah, I know you do. No, I'm not going to do that. Okay, that's interesting. State, well, how do you feel about Mr. Dailey asking Mr. Pearcy to testify today?
No.
In front of us, or?
Yeah, in front of us, yeah. No, I'm not going to send him back to talk. I mean, That was an oddball one-time try with his mom and his stepdad, but is there any reason that here in court, I mean, again, I know it's unique, but we're in uncharted territories here 35 years later, so I'm trying to think of a way to resolve it. Maybe if Mr. Pearcy heard that Mr. Dailey wants him to testify, maybe that would help. You willing to take that chance? They are.
Our only concern is that there's been, in the deposition, Mr. Pearcy testified about this, and they already have record evidence about all this communication between Pearcy and Dailey. The state's not comfortable with any communication between them because they have a history of sending communication to each other.
Well, that was secret communication in the...
I still, it concerns the state based on their prior history that they communicate with each other and have communicated with each other in ways that we don't even know.
How about this? I could ask Mr. Dailey here if he wants me to encourage Mr. Pearcy to testify, and then I could communicate to Mr. Pearcy, I've spoken to Mr. Dailey just now, and Mr. Dailey is hoping that you will testify. How's that sound?
I'm fairly certain that Mr. Pearcy is aware of that without you having to make that inquiry. That's been blatantly clear again and again and again.
Okay. Still, is there any good lawful reason for me not to do it, though?
There's no lawful reason for you to do it either at this point.
Just trying to, you said you wanted it done today. I'm trying to get it done today.
I don't see.
I think we've run up the flagpole as much as we can, send mom and dad back.
I know.
I'm uncomfortable with having communication between two co-defendants about how they're going to testify or not testify.
All right.
That's not what I was saying.
I know you weren't saying that, and I know what you're saying too, and I took a shot. They said no, it's no. All right, so we'll bring him in. I'm going to try and swear him in. I'm going to talk to him like a gentleman, and you two are going to talk to him like gentlemen as well when he's up there, okay?
Well, Judge, it's my understanding then at this point, you're going to ask the defense to call their witness to the stand.
No.
Yeah, he's my witness.
Yeah. Oh, did you want to give your opening now?
No, I'm not going to do any opening.
Okay.
I'm ready for the defense to call their witness to the stand.
Okay.
And then we'll figure out exactly what he is or isn't going to do, and we'll start going down that road.
Right.
Because he's already said, I'm not going to testify.
Yeah.
But it's their witness, their burden. They need to put their witness on the stand.
I understand. Everybody understands. We're all on the same page. All right. Let's bring Mr. Pearcy in, and now he's coming up here and tell him to face me and raise his right hand.
Exactly what I said. Exactly what I said. What? Sir, step right up here. And once you step up there, face the judge and raise your right hand to take the oath.
Good morning again, Mr. Pearson. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Yes. All right. Have a seat.
Pull your chair up.
Yeah, you're on.
Oh, one second. So, and also they said your laptop creates massive feedback to the entire system when you put it up there. So don't put the laptop up there. You can use it from your desk, and you're welcome to question from there if you wish. It's just I don't want to create all this.
I'll come on back.
Okay. So, Mr. Pearcy, welcome back again. I gave your mom and your stepdad an opportunity to talk to you about the situation to see if they could help persuade you to testify. It's my hope that you're going to answer the questions of the attorneys. Like I said, I promise that I'm not going to allow them to be disrespectful to you. And we're going to go from there. Do you have any questions for me before we start?
No questions, but I'll plan on testifying.
Okay, well, we'll see what happens. You may inquire.
Yeah, approach the podium.
Yeah, wherever you're comfortable.
Good morning, Mr. Pearson. You and I met for the first time on December 18th, 2019 at the Sumter County Correctional Center, correct?
Mr. Pearcy, I'd ask that you'd answer the questions. Are you going to continue to refuse to do so? Pearcy, have I treated you with any disrespect today? No. You're a citizen of Florida, not voluntarily necessarily at this point, but you're a citizen of Florida. Do you accept that it's your responsibility to follow the rules and the laws of the state of Florida if you're a good person?
Yes.
One of those rules and laws is that in the event that you're called as a witness to testify in a case, the expectation is that you'll give honest and truthful testimony. Your mom and stepdad are here. They consider you to be a good person. I don't have any reason to believe otherwise at this point, that you'll conduct yourself like a gentleman if you agree to act. There's no disadvantage to you testifying. In other words, you won't be punished for it in any way. Is there anything else I can talk to you about here before I get your next answer?
No, sir. I've done 35 years for a crime I didn't commit, and I don't plan on testifying against somebody else to help the state kill them, and that would be all my testimony could basically do, so I have nothing else to say. I did that 3-hour depo and asked and answered all them questions. I don't have nothing further to say, sir.
Okay. Do you have any further questions, Counsel?
Yes, I've got 2 more strikes, yes?
2 more strikes, you're correct. I'm glad to keep the score too. Give it another shot.
Mr. Pearcy, it's your position, sir, that everything you told law enforcement, the police, when you turned yourself in, that being closest to the crime is your correct statement, right?
Strike 2, you got a third question?
Mr. Pearcy, when I went to see you on December 18th, I told you I wanted the truth. And you told me, Jack Percy.
Your Honor, I object. It's leading
Sustained.
to proper question.
He's obviously an adverse witness, Your Honor.
He is not an adverse witness just because he's not answering the
Hold on,
questions and
hold on a
not giving
second,
you the
Artie.
answers
Art,
he
hold on a
wants.
second. We don't need to do that. Mr. Dubin, if he's not going to answer the question, I'm not going to answer the question. I'm not going to let you tell a story and then let him sit quietly. He's not going to do it. Mr. Pearcy, I got to tell you, I'm pretty disappointed here. You've been treated with respect and courtesy. Is there a good reason why I shouldn't hold you in contempt for what you're doing? No? Mr. Pearcy, do you mind if I ask you a question?
Go ahead, sir.
You've given basically 2 different stories. One story you tell, you were in the car with Mr. Dailey. The other story you tell, you would attempt to exonerate him, and you've given sworn testimony to that, or sworn statement to that 3 times. You understand, is it 2 or 3?
2 different times they brought me statements that I signed.
Okay. 2 or 3, it doesn't matter, I guess. You understand that in the future that's not going to work. We're not going to be doing that anymore. I've brought you here so that you could tell your story, and I've made sure that everybody's treated you with respect the whole time. I want you to know that we're not going to be doing this again. So today's your last day to do this. Your mom's here in court. She wants you to hear you to tell the truth, and this is your chance. Why can't we just get another 2 hours of your time here of testimony, and we'll all be done with this and go our separate ways? Can we do that? Nothing I can do or say to change your mind. All right, Mr. Pearcy, you can go.
Go ahead and open that door there.
Nothing I can do, Counselor. He's not going to talk, and we're not going to sit there and stare at him for 20 minutes. If I thought I could budge him, I'd budge him, but I don't think I can budge him.
Your Honor, Mr. Dailey would call Miss
Sue? No, he's going to sit back here for a little while.
Before I call my next witness, I would ask the court on the record to hold him in contempt.
To what end?
I think I stated it earlier, Your Honor. I think that not doing so, I understand that it may not have any impact on him personally. I think to keep the integrity of our system, someone cannot hold what he's doing. There needs to be a consequence for it.
Well, it wasn't me, but it was a judge like me in the circuit court of the 6th Judicial Circuit that took the very rest of his life away from him and sent him to prison for the very rest of his life. I'm not really sure I can take much more than the rest of his life. So I don't see any cause to hold him in contempt. I don't think it advances anything to hold him in contempt. And I'm out of ideas and or alternatives. Biggest concern I have at this point is you're telling me you want to call your next witness, but we're here for claim 1A. And claim 1A, you told me back when I set this and agreed to hear it, was that Mr. Pearcy will testify he acted alone consistent with the statement that he gave on December 18th of 2019. You've not given me 1A. Do you have any other way to give me 1A?
Yes, I'm going to give it to you after I call my witness, but his testimony, that deposition, is absolutely admissible. Absolutely admissible, and I'm going to go through my argument if you'd like me to do it now.
Let's do that now. I want to hear why his deposition is admissible, but also, as you're telling me why it's admissible, tell me how that meets 1A, because 1A was that Mr. Pearcy is going to tell me that he acted alone and your client wasn't involved, and yet I can look at, on that deposition, 13 different pages where Mr. Pearcy says he lied, that your client was the one that did it, and he lied to keep him off death row, which he's succeeded thus far in doing. I mean, as far as keeping him from being executed, he's stalled us for the last 27 years, effectively, since his first statement in 1993. So how is that giving me 1A, even if I admit the deposition?
I intend to go through that, but
all right.
If you want me to start there, I can start there.
Start there. Well, no. Start with how it's admissible, because if it's not admissible, it doesn't matter. If it is admissible, then it matters.
Very well, Your Honor.
Please do it in the right order.
Okay, Your Honor. And if you would indulge me for a few moments.
Do what you need to do.
I want to start by saying that earlier, Your Honor referenced the Florida Supreme Court opinion when I alluded to this argument. I want to make very clear from the outset, that opinion was not this situation and not even close.
Right. That opinion was 279 Southern 3rd at 1208 Florida Supreme Court, Dailey versus State.
Yes, Your Honor.
It was rendered October 3rd of 2019. Just keep the record clear. All right, keep going.
That was a situation where Mr. Pearcy signed an affidavit saying that he killed Shelly Boggio by himself, that James Dailey had nothing to do with it. In that case, or in that instance, when he was called to court, there was no deposition. When he was called to court to testify, he shut down, pled the fifth. All right? Prosecutors did not cross-examine him. Maybe they could argue they didn't have the opportunity to cross-examine him. Here, Your Honor, this is former testimony, and there can be no doubt about it, where they had the motive and opportunity to cross-examine him, and they did not. So where we start is that this is former testimony, and it qualifies as the former testimony exception to the rule against hearsay. It can be I don't think that there's really any even debate from the state that Mr. Pearcy has rendered himself unavailable. He has well settled in Florida that when someone pleads the fifth, they are unavailable. I can go through the cases, I can go through the statutes, but it's Florida statute section 90.8041, where it expressly says that. And again, I don't think that there's much debate that he is unavailable. And there can be no doubt that this was former testimony. And the Florida rules of evidence, Your Honor, permit the admission of an unavailable declarant's former testimony, including testimony taken at a deposition, so long as the party against whom the testimony is offered had an opportunity and similar motive to develop the testimony at that deposition, whether by cross, by direct, or by redirect examination. And it could not be said plainer. In the Florida statutes, of course, it won't work right away, so if you give me just a moment.
Are there any buttons I have to hit? Oh, there we go.
Oh, I'll just read it to Your Honor.
Check your connections, make sure nothing got loosened over there. Might be a video feeds.
Your Honor, I'll just read it.
Okay.
Florida statutes annotated section 90.8042A. 90.8042A. The general rule against hearsay does not apply to, quote, testimony given by an unavailable witness at another hearing or the same or different proceeding or in a deposition taken in compliance with law in the course of the same or another proceeding if the party against whom the testimony is now offered, or in a civil action or proceeding, a predecessor in interest, had an opportunity and similar motive to develop the testimony by direct, cross, or redirect. The rules of evidence do not require that the state elected not to cross-examine him, and they don't require the state to have actually cross-examined Mr. Pearcy. All they require is that they had the motive and opportunity to do so. And there's no question that they had both the motive and opportunity. The state had full and fair opportunity to cross-examine him. For whatever reason Mr. Martin had, he made the strategic decision at page 141, lines 2 through 4. It was me, but I said, okay, all right, I don't have anything else. And Mr. Martin, the state has no questions. Now, that decision was not hampered by any lack of information by Mr. Martin's part. The state exhibit list for the hearing contained 19 instances of former statements by Mr. Pearcy. They didn't learn about these statements last week. They've had all of the information they needed to conduct a thorough, searching cross-examination. Now, the next question is, did they have the incentive or the motive to do so? There is no question, Your Honor, no question that they had every opportunity to not only conduct the cross-examination, but a strong incentive to do so. They knew that he was being deposed for the purposes of this hearing. They've been engaged, and I think Ms. Mack said it, in a decades-long effort to maintain that this man had something to do with this crime. If they stand up here and say, well, we were prejudiced in some way, they made the conscious decision not to cross-examine him. They knew right there that he had, in the past, when he comes into a courtroom, did what he did today. I don't know what earthly explanation there was for it, but that was their decision that they have to live with. Now, to the extent that they will come up here and claim somehow, because I can tell you, Your Honor, and I say this with all respect, but with full confidence, that this could not be clearer that this is admissible. And to the extent that they come up here and say that this was a discovery deposition, there is absolutely no question that it was not. The rules of criminal procedure governing pretrial depositions simply do not apply in post-conviction proceedings. That is well settled Florida law. I could give you the cites if you'd like them. Hurst versus State at 18 Southern 3rd, 975 at 1007. Hayward versus State, 183 Southern 3rd, 286, 322, and at note 13. All of these cases saying that Rule 3.190 is not applied to post-conviction proceedings. This was not a pre-trial discovery deposition. And Your Honor, we have thoroughly researched this issue for more time than I care to admit to this court. We could not find a single state court decision in the state of Florida that restricts the admissibility of a deposition when that deposition testimony was taken in connection with a post-conviction proceeding on the basis that the deposition was a discovery deposition. Now, Your Honor, what is new? What is new? We now have.
Well, let me see if the state's going to object first. Let me compartmentalize and do this in kind of a linear way. State, you want the opportunity to respond to the admissibility of the deposition?
Sure, Your Honor.
All right, let me let them respond.
Yes,
sort of keep it in a linear fashion here.
So the state's position is that this is a discovery deposition. Whether it's in post-conviction or pre-trial, this was done for purposes of discovery in preparation for hearing. Yes, the typical rules of evidence, the typical rules of criminal rules don't apply in a post-conviction motion, which is why we have to ask for leave of court. That doesn't mean the civil rules then all of a sudden apply. What it means is we are asking for the leave of court to conduct a discovery deposition. They never asked for leave of court to do a deposition to perpetuate testimony. If they would have done so, you know how that process works. It's a motion with a whole slew of things that have to be done. Instead, we are in a position where that was a discovery deposition, and the law is very, very clear when it comes to discovery depositions that they are not admissible. They are not considered subject to cross-examination, and it's not an appropriate tool for parties to conduct cross-examination. It is a tool that is used for purposes of discovery, and that is all it is. So to get up and say, we conducted that deposition for purposes of entering it into evidence, when they informed no parties that that was their intent, is, one, to the state disingenuous, and it's sneaky because they didn't tell anybody that. They didn't tell the state and they didn't tell the court. Now at the 11th hour, they're coming to the court and saying, oh, no, Your Honor, this was the plan all along. We wanted to do this deposition for purposes of getting it into evidence. Because that's a whole other issue than we want to do this for purposes of discovery, which is what they came and asked the court for. Your Honor, can we do a deposition of Mr. Pearcy? We come and we ask for leave of court on those issues in post-conviction. That is appropriate for purposes of discovery, which is what happened. It's a pretrial discovery issue. The same way it applies in a pretrial hearing and post-conviction. The case law is the same and it's completely appropriate. The state wouldn't ask any questions. All the questions at issue were covered. We would ask the questions in cross-examination at trial at an opportunity when cross-examination is appropriate. We would also ask those questions in a deposition if it was a deposition to perpetuate testimony. But neither a deposition to perpetuate testimony isn't going to be appropriate because he's not unavailable. He's here, he was brought down. The fact that he's unwilling to testify is another issue altogether, but he is present in the courtroom. So again, the state's position on the state's position on this is that it is a discovery deposition, and so it's not admissible in evidence. There's plenty of statements in that deposition that the state would love to put into evidence, but it's not appropriate, and so we don't think that it should be used as evidence.
Okay.
Your Honor.
You want a response?
Yes, Your Honor.
Yeah, go ahead.
He is unavailable. If you just look at statute 90.8041, he's absolutely unavailable. And here's the point. The point is that they find out. Let me just back up and address all of their points in kind. Okay? Your Honor, to call this a discovery deposition at this point, first of all, they have waived, and there's strong case law on that, which I'm going to get to in a moment. They have, by not objecting at the CMC, by not objecting at any point, they can now not come in here and say, oh, well, it should have been a deposition to perpetuate testimony. I'm going to get to that in a moment. But if you look at the Florida case law, there have been two reasons why testimony obtained during a typical pretrial discovery deposition has been held to be inadmissible at a subsequent trial. The first is that the defendant is not entitled to be present, you know, that there's a confrontation clause issue. And the second is that that there should be an opportunity to engage in adversarial testing of the evidence against the defendant. Now, both justifications for this rule in the pretrial setting quite obviously don't apply here. First, the fact that Mr. Dailey did not attend the deposition is of no importance at all. Mr. Dailey is offering Mr. Pearcy's testimony here, and the confrontation clause doesn't protect the state. It's supposed to protect the defendant. And second, the context of the request that we made for Mr. Pearcy's deposition could not have been clearer to all involved. We said we were going to be requesting the deposition of Mr. Pearcy in advance of March 6th during the hearing at the CMC. And the state knew exactly what the context was. In their brief in opposition to our motion, what they did was they started weaponizing Mr. Pearcy's prior refusals to testify in court under oath and subject to cross-examination in support of their argument, which they then abandoned in the conclusion, and that the court did deny the motion. But what's interesting is that they're now saying, oh, well, this was a discovery deposition. It doesn't make any sense. And if we use our common sense, think about it this way, Your Honor. If they feel like this was some discovery deposition to engage in some sort of fishing expedition, as the Lopez case says, they knew why we were there. They knew that we got this declaration. It was attached to our motion. We both had access. If they wanted to ask questions, they could have. The sole reason for us to take that deposition in the first place, the sole reason was so that we could finally, after all of these years, get his testimony under oath and subject to cross-examination. They knew what he might do. We knew what they might do. And, you know, and when we made the request...
Can I ask you a question? Yeah. Because you said that they don't know it was a discovery deposition. They didn't think it was a discovery deposition. They never objected to it being a discovery deposition. But I'm not blessed with an eidetic memory, but I've got a reasonably good memory. I read the deposition enough times to know that on page 129 at line 21, the second time Mr. Martin objected, the first being back in the 50s someplace, Mr. Martin objected and said, it's clear that you're abusing the privilege of a discovery deposition, so I'm going to object. And I'm basically asking that you stop because you're absolutely abusing the discovery process.
If he's, because he, first of all, in all candor, he was, yeah, okay, he could have said that. It does not change what it was. Okay. Just because he said that doesn't change what it was. Because they knew full well in our response, in their response to our request for a deposition at the CMC, we made it abundantly clear. They said we don't have any objection. And then what's interesting is Ms. Max said when we were scheduling it that Mr. Martin would be, quote, handling the cross-examination of Pearcy. Would be handling the cross-examination. Quote, Mr. Martin will be doing all of the cross-examination and that stuff. That was when we were scheduling the deposition. If it was merely for discovery, why would they have ever been concerned with Mr. Martin's ability to cross him and to be at the deposition?
Counselor, just to stop you there for a second, I took when she said that, meaning that when we had the hearing that Mr. Martin was the one that was going to cross-examine Mr. Pearcy, not that it was at the deposition, but that's the way I took it when she said it.
But we were talking about in the context of scheduling deposition. But we could agree to disagree on how it was taken on that. But by failing...
Since I'm here, I can tell you that the reason why...
Well, I'm going to let you speak next. Let me just Been letting him finish. I'm just trying to get to the bottom of all this. Keep going.
I want to give you a case, Your Honor.
Okay.
State versus Charles. 827 Southern 2nd, 1107 and 1109. It's a Florida 3rd District Court of Appeals case. And that court specifically found that waiving any objections to the introduction of deposition testimony by failing to object affects the state's application for a deposition. Here's the point. If you don't, they never objected. There's another case I want to give you, Your Honor, to please look at. State versus Wells at 538, Southern 2nd, 1292, Florida 2nd, DC 1989. In that court held, quote, the party's failure to object to the absence of either a written order or an appointment of a commission issued to take a deposition to perpetuate testimony constitutes a waiver of these procedural defects. They had every opportunity and every motive to cross-examine him. I understand that Mr. Martin may have said that in the deposition. You know, it was interesting. At some point, Mr. Pearcy says, well, at the end of the deposition, I said, and I'm saying everything that I'm willing to say here today. If you bring me to court, I will plead the fifth. There can be no clearer expression that at that moment in time, he knew full well that was his opportunity to cross-examine Mr. Pearcy, and he elected not to. And I would ask you, Your Honor, to please let the truth come in. I can get to the new evidence in a moment. And I can address it now if you'd like, or after the state responds. But the state themselves, when they visited Miss Simon, according to Miss Simon, said, we do not want to execute an innocent man. If we want to get to the truth here, all we're asking you to do, Your Honor, is to follow the law and to admit the deposition.
Okay. State, any final response?
Only final response is, Your Honor, that I think Mr. Martin's statement speaks for itself. The state believes it was a discovery deposition. He objects to it based on the fact that it's a discovery deposition and that he's abusing the privilege of a discovery deposition. In addition to that, my statement at the hearing was about Mr. Martin cross-examining witnesses at the evidentiary hearing, and that was going to be Mr. Martin's role. Thus, he would be the person who would be present at the deposition since he was in charge of the witness. One further, just a cite for Your Honor.
No.
On the discovery deposition issue versus depositions to perpetuate, State versus Lopez, 974, Southern 2nd, 3. That's it. Thank you.
Give me a moment. All right,
I have nothing, Your Honor, before.
what?
I just had one more point.
Yeah, sure.
Sorry. You know, looking at the statute, 90.804,
Okay.
once he's unavailable, which he is, the hearsay exception related to former testimony makes no distinction about how that testimony took place, whether it was in a discovery deposition or otherwise. All it says is that testimony given as a witness at another hearing of the same or a different proceeding or in a deposition. It doesn't say, oh, but by the way, not discovery depositions. It just says, or in a deposition, taken in compliance with the law in the course of the same or another proceeding. That's it. No distinction.
Well, it's 12 o'clock, and here's what I'm going to do for you. I'm going to take lunch, I'm going to look at a couple of your sites. In the event that I rule that it's admissible, I want to hear how it gets me to 1A anyway.
Yes.
If I rule that it's not admissible, I'll still hear how it gets me to 1A. If I have been incorrect about it, because I want to create as much of an appellate record as I can, so that if it's going up, that they'll see that I looked at the next line as well. And so I'm still going to hear either way why Mr. Pearcy's deposition gets you past 1A and into cumulative. You said you had a witness you wanted me to hear from about 1A. Who's the witness you want me to hear from about 1A? Besides Mr. Pearcy.
Ms. Simon.
About 1A?
Yes. Because it goes to, there are things that are said on those phone calls that make it clear that what Mr. Pearcy has done is, well, I would rather, actually, can I approach with this? Because there's, the witness is important.
Oh, all right. That's a good point. Before you decide on that, though, and calling her as a witness, don't you want to hear the other phone calls that DOC has?
I mean, if we're, sure, I would like to, sure.
All right, I
would, yes.
I'm not going to do this and then have you come back 3 months later if I rule against you and say, well, we want to hear those other phone calls first.
Sure.
And I haven't heard a good reason why I shouldn't have those other phone calls given to you. And if I give you those phone calls, it's 3 hours worth of phone calls if they used all 15 minutes on all 12 calls. And I'd rather do it comprehensively than in two pieces.
We do think those calls are critical.
I don't know. You're telling me you heard things, though, in the first two calls that you thought get you past 1A?
I think there are things in the first two calls that are completely relevant to whether or not he made an admission to his mother at some point, yes.
All right. All right, well, let's take lunch. We'll come back at 1:30, and when we come back from lunch, I'll take a look at a little bit of what you've cited to me on the deposition, and I'll give you my ruling, but I still want to hear how the deposition, even if I admit it, gets you past 1A, because that's the most important part.
Your Honor, real quick, 30 seconds. In the event that you, in the hopefully unlikely event that you rule against me on that,
yes,
can we have an opportunity to brief it? I'll think about it. Okay, thank you.
All right, we're in recess till 1:30. Yes, that's about it. Yeah.
You can send it down to the jail. And the other guy's gonna be coming in. Hey, the other guy's coming in.
David Oppenheimer has left the conference.
DOC guys. Are they going to feed the DOC guys?
Well, I was just gonna actually, well, their major is out there. I don't know what their major is. I was gonna do it again. They can, but these two, I would think that, I don't know how many have to stay with you.
Excuse me, sir.
Yeah, but they're all. Well, if he lets it, it's open.
Where are you in the courthouse? Right?
Yeah, we have one.
Yes, sir. Yes, sir.
I'll go lock it.
Actually, one.
Oh, yeah.